get started. Thank you for coming to the second webinar in our series on farm succession and transfer. As this opening slide shows, today we're going to focus on legal considerations. In a moment, we're going to bring up an attorney, Daphne Moritz, who works in both Vermont and New Hampshire, has worked with us on this presentation over a couple of years, and done a presentation similar to this for previous series the UVM extension used to put together, which is where I first became familiar with Daphne, and she works in both Vermont and New Hampshire. And if we could bring up the funder slide, I think we can then. Is there another slide there? Well, yeah. So again, I want to thank our funders, Vermont Housing Conservation Board, the Connecticut Department of Agriculture, and USDA, National Institute of Food and Agriculture. And with that, let's let Daphne go ahead and share her slides.
How to do this once again.
Yeah, toolbar on the bottom, and share button, share screen button.
Hopefully, I don't know. Now I have like more than one here, but let's see. Hopefully, yeah, this is the one. Share, and then somehow get rid of this. Yep. How do I get rid of this top bar?
Well, you've got slideshow, go to from the beginning on the left, and then you should get your slide should come up. Yeah, below that, not file. Nope.
No, I'm trying to get, like it's covered.
Yeah, can you just slide down below file, just hit from the beginning, and then you should be able to your left, to your left. There you go.
Just from the beginning.
There you go.
Now,
there you go.
Is that it? Okay.
Yep. Now you're up.
Tech stuff. Okay. Hi, I'm Daphne Moritz. The next slide just shows who I am and how to find me. I thought I had I do have my email up here. So if anybody has burning questions for me that I did not address in this show, you guys can reach me. I used to have an office in Hanover, but for years I just used my White River Upper Valley location. Sheehy, Furlong and Beam, my law firm, is in Burlington, but I only go to Burlington when necessary. As you can see, I live in the Upper Valley where it just snows all the time. It's awesome. Okay. Well, and that's
so just a reminder, everybody, please keep your microphones muted. And if you'd like to ask questions while Daphne's presenting, please go ahead and put them in the chat, and we'll read them out to her, or maybe ask you to open your microphone if it needs a little bit more back and forth. I think after the first portion on estate planning, we'll definitely take a break where that's specific to asking questions, where people will definitely be invited to open mics before we go into the other section on business planning, and then, or business entities, excuse me. And then we're hoping to have 20 minutes to half an hour at the very end for any and all questions.
Right. And I was just going to say that kind of question thing too, because I want to make sure that everybody feels comfortable that they can find, either put their little hand thing up if they know how to do that, or put something in the chat. It's nice to have the questions like in real time, because sometimes at the end of a session we forget. But yeah, having a break, I'll probably ask after certain sections too, when I just feel like all I do is talk. Okay, so today I'm going to cover estate planning, long-term care planning, and then this whole legal entity formation, moving assets, business operating agreements. And then Mike liked this divorce, disability, disaster, disagreement, and death. But in my presentation, it's all woven in. So I don't know that I'm going to actually speak to each of these things specifically, but if anybody has a real burning question about any of these that doesn't come up, please ask. All right, one thing I just like to remind people is doing nothing is also taking action. In some cases, doing nothing can work out, but in most cases, it won't be a good idea. So get your team together, your advisor, your the person who works for the Extension Service. Obviously, you're here, so you know some of this already, and your lawyer, your accountant, and start the process. And probably the sooner the better. So, when it comes to estate planning, I will give you a very broad overview. Some of you probably know some of this because you either had a person in your family who died, and you had to go through a process. Maybe it was the probate process, or maybe you were acting as the power of attorney for someone. So I know that it could be a little stuff that you already know, but let's just launch in. Let's say I have a couple. I'm going to try to keep this couple in mind as I go through, even though I don't have examples in my slides. It's Glenn and Lee, and they've been married for many years. They're in their 60s. They have 3 kids. Their kids are grown-ups. 2 live outside of New England, maybe in New York City, not interested in farming. But let's say their son is interested in farming. He's married, has a couple of kids. So we have some generational thoughts about Glenn and Lee. Hopefully I'll remember all their details. But they not only have like a nice 200-acre farm that has they've diversified their crops, mostly plants, and not so much livestock at this point. Lee had worked outside of the farm in her early days. She was a teacher. She now has a pension. She also might have like a small IRA. Glenn was able to do a little bit of savings. Maybe he has a SEP fund or something like that. Their retirement assets aren't ginormous. They just have some. They also have a small investment account. They have regular bank accounts, and they have the whole farm business side. But they haven't, let's say they've just been an S corp. Or not an S corp. They've been a sole proprietor. They've never done a corporate gig at this point. But they come to me for estate planning because they haven't done that either. Even as all their children were minors. But they decide, well, we better talk to someone. So I'm going to talk to them about a will, probably in their case, a revocable trust, because I anticipate that we might be talking about LLCs and other, other structures, but definitely like how they're going to transfer. That's going to become a relevant conversation. I also will talk to them about powers of attorney, healthcare powers of attorney, or in Vermont, we call them advanced directives, and HIPAA authorizations. So what I like to start with are the conversations about what Glenn and Lee really want. It's not so much that I want to dive right into their assets before I figure out what's important to them. So that's kind of combining their values. Then I'm going to start talking about their assets and their goals and how these things can mesh. I don't anticipate that Glenn and Lee will have estate tax planning mitigation in their case. Now, we might have people from Massachusetts on here. I don't know if we do. But if we do, the estate tax exempt amount, the last I checked, it might have changed, was only $1 million. And when I think about that and the value of farms in Massachusetts, I think, well, in your state, you guys probably do have to think about estate tax mitigation. Federal estate tax isn't usually a non-issue for most of us. It's like $13 million per person now. That's the exempt amount. But, you know, $1 million these days, it's like you add up real property and suddenly you're there. So I won't get into the weeds, but that might be a conversation the lawyer does have with the client in terms of estates. And anyway, we talk, I draft, and we talk again, and then eventually they sign their documents. And then we talk, once we have a trust, we'll talk about retitling assets into trust. So that's like a very broad overview. I don't know, I should have checked these slides. They're like, they're staggered. So other items we might talk about are asset protection strategies and long-term healthcare needs. And these two items I'm going to talk later on in our conversation about long-term care. The things that the documents I think are most important are healthcare powers and durable powers of attorney, if you can believe that. That's because you're still alive when these powers are important. When you die, these powers die with you. But when you're alive, and if something happened to you and you couldn't speak for yourself, and if you didn't have healthcare powers or financial powers, your person, your spouse, your child, sometimes a person who's related to you or a friend might have to move for guardianship if there's no other way to help you basically keep the lights on or make healthcare decisions. That's if you can't speak for yourself. Advanced directives are probably the number one, because we think about our health as the number one most important item in our lives, and it conveys your wishes, and you want to make sure that you have as much imparted as your state allows you to impart. Vermont is very broad in what it allows with advanced directives. New Hampshire is a little different, and they still use, I think, healthcare powers and living wills. I haven't done one in New Hampshire for a little while, but the last I did one for a New Hampshire client was that bifurcated. Vermont just like threw everything together. I can't speak to the other states in New England or New York or anything like that, but I just know you want to make sure with both advanced directives and health financial powers of attorney that you name someone who you feel very confident can be an advocate for your wishes or know exactly what you want. Durable powers of attorney are important even if you do have a revocable trust. Some people think, well, my trustee has control of all my financial pieces, and often that's true, but retirement accounts, life insurance policies, sometimes random credit cards, sometimes business interests are all might live outside of your trust and your trustee's purview. And I also like to call it, just to be a little bit low key about it, it's like somebody to keep the lights on for you so they can pay your utility bills, make sure that your taxes are paid, help you apply for Medicaid if that's the case, although you don't always need an agent to be that person, and just general banking and insurance matters. These also are powers that can be triggered or effective immediately, or they can be triggered on a doctor saying, like one of the triggers could be a doctor saying that you're incapacitated. I think, to me, what I often say to clients has to do with the client, him or herself. If it's an older client and anything can possibly happen on any given day, I try to kind of guide to having the powers effective immediately. just make sure you are, naming somebody you trust inherently. I do see a lot of things happening in the chat. I haven't clicked on the chat, and I don't know if there's questions bubbling up while I'm talking, or if I
Yep,
should.
no questions yet. They're just
Okay.
answering the polls. So
Okay, perfect. Thanks. Okay. Power is also, you might have known in your lives of like real estate transactions, they can be limited to, often it's like a real estate power of attorney, especially if you have out of state purchases of real estate. So if there's no questions about powers of attorney and advanced directives, I'll move on to wills. Most people know that wills are a place where you can express your wishes, and you name your executor, and when you die, if you have any assets in your name alone, then those will have to go through probate. Now, there's many ways to try to get your assets not to be in your name alone, and also not necessarily losing complete control over them. But it's kind of, people don't always remember. Like, so if I have the same couple, Glenn and Lee, I talked about, they have IRAs, and they might have, I wanted to say they also have life insurance policies for each of them. And right now, they own their house and their acreage, everything kind of in the farm, as in a joint tenancy situation with rights of survivorship. They might have a couple of regular bank accounts. They own those jointly. But let's say Glenn has another account that he just opened, because it was more convenient, and he never thought to put Lee on it. And Glenn dies, and there's $12,000 in that account. There's no way that even as a wife, if it only belonged to Glenn, that Lee has any way to get that $12,000 unless she opens a probate. And usually something for, say, under $50,000 would be like a small probate. Depending on your state, it's going to be a different value. Or there's an easy process. I forget in New Hampshire if there's not a small probate, but there's an easier process for either spouses, or just in general, you can get like a summary administration. But at any rate, it's not the most grueling process, but it is kind of a drag, right? So that's when you think about the probate process, it's also always linked to someone dies with something in their name alone. So usually I try to give my clients ideas if they don't want to have a revocable trust, because not every client, I don't actually push revocable trusts, trust mill, and lots of clients can do things that provide either a beneficiary designation. So you already have those. When you have an IRA or another retirement account, you have to name beneficiaries. And life insurance also has beneficiaries. Now you can name your estate to be your beneficiary. Generally, if you have a trust and you have life insurance and you don't want your 20-year-old child to suddenly get a $500,000 life insurance policy, you might put your life insurance policy to go through your trust. But often, where there's beneficiary designations, you don't even rise to the level of having a trust, because that's avoiding probate. And you can go to each bank account and either do a transfer on death, or husbands and wives, like I said, will have joint tenancy with rights of survivorship very often. Okay, so the other really important point about wills is if you do have minor children. So Glenn and Lee will go back home and say to their son, you should go see Daphne because you have minor children and you need to have a will so that there's a guardian named for your minor children. Also really important. If you don't have a will, your estate will pass through the laws of intestacy. Again, if there's nothing that goes through the probate estate because nothing's in your name solely, no harm, no foul, I suppose, but most people end up having, something we can't protect for everything. So let's say you have a Social Security refund check come in the mail after your, not Social Security, nursing home refund check come or an IRS, a tax refund check come in the mail after your death. And now it's enough money not to be oh, forget it, we're not going to deal with it, but it's a couple $1,000, somebody wants to deal with it, you have to open a probate. So rather than just leaving it to your state laws of intestacy, meaning you died without a will, you can guide the process a little bit, even though you are not there, but you do it for your people that you love. Okay, so I talked a little bit about the probate process. I should just do this. The court oversight isn't that bad in Vermont and really not in New Hampshire, but I have had situations in Massachusetts. I'm not licensed there, but I've dealt with Mass attorneys on estates, and it can be a little bit tedious. Takes a really long time there for some reason. So just know that. Wills can be amended. We call will amendment a codicil. Okay, let's just move on to revocable trusts if there's no questions.
So maybe if I could just make a few comments on some of the things that you said.
Sure.
One of the things, and you mentioned particularly with the younger member of the family having younger children, that they should, because they should have an estate plan because they need to name guardians. And that's been one of the things I've seen hold back people because they're not sure who they want their kids to go to. And there's often disagreements in couples about where they would want their kids to go to if they both pass on. But I tell people, don't let that be an excuse for you not taking care of these other documents, because even as some lawyers will say, as soon as you're 18, you really should have a will, powers of attorney, powers of medical attorney. And so we really want the younger generation here to be thinking about this, that this isn't just something for your parents or waiting until you're married and have kids, or that you are a part owner in the farm. You should be thinking about this at a younger generation. And for all those things, just two anecdotes. I've worked with, well, two related anecdotes. I worked with someone whose 22-year-old son was working on a feedlot up in Canada, was run over by a tractor. So the parents didn't necessarily have the medical power. He was 22 years old. There was nobody that had the medical power to make decisions. Another farmer here who's at Central Vermont was working in the farm, and a tractor rolled over on him. He was in his 40s. He was divorced. His parents didn't have any medical powers of attorney for him. And so while he was being put on the helicopter, he had to tell, before he passed out, had to tell the paramedic, my mother has the rights to make decisions for me. That's not really where you want to be. So it's across all generations. You really need to get those documents in place and think about those people. And then the last thing I'll say is that the power of attorney and the medical care agent may be different people. I've seen people select people they feel this person's going to be better able to make medical decisions for me, and this person's going to be able to better make financial decisions for me.
Right, absolutely. All those things are true. It makes me think that my own kids probably have to get on with it as well. So yeah, because anything can happen, and it's awful in a crisis to have to start thinking about, oh no, now I have to have an emergency guardianship for my kid, or I mean, God, in another country, let alone, yeah. Okay, well, lots of things can happen. We won't think of all the outliers, but yeah. Okay, let's move on to revocable trusts, because I'm always mindful of the time. I think I have so much time when I'm practicing, and then I have no time. Well, what I like about trusts, and what I would tell Glenn and Lee in their case, is this would afford them the most protection, or not the most protection, lies, the most control during their life. Definitely not the most protection. I'll just, because I said that, I want to just go back and say, people think that a revocable trust protects them from creditors and predators. It does not. That you still, it's kind of like I say, it's me, myself, and I. I have $100 in the bank. I control that as me. If I put it in a revocable trust, I'm generally keeping my own social security number, but even if I didn't, I still have control over that $100. Even though my trust owns it, I'm going to name myself as trustee. I'm also going to name myself as beneficiary. So that's why I say it's me, myself, and I initially. And there's no real protection at that level. But there is a lot of control, as I just pointed out. And the nice thing about it is it works during your life. So if you become incapacitated during your life while you have a trust, your successor trustee, a person that you named, that you trusted while you were well, has control and can administer your trust exactly the way you've written it. So it is a really nice instrument. You know, it still is going to provide for the time when you die as to how the distributions are made, but you also avoid probate. Now, in many cases, if a person has, say, or a couple comes in, they're a blended family, if somebody comes in and they have experienced divorce and seek some sort of future protection, maybe a trust is important. If they have tax mitigation, it's important, but probate avoidance is good too. So funding your trust is very critical. It's not just, you know, trust is like this piece of paper and you sign it. What's really important is how you fund it afterwards. So for Lee and Glenn, I might say, well, while we're talking we're in the middle of talking about farm succession stuff. So let's put your farm, well, let's think about putting your farm in your revocable trust. Now, we may or may not do it. It really depends on their liability situation. So if they're in the middle of something, maybe holding the farm as tenants by the entirety might be okay at that moment in time. And in the future, we would put the farm in their trusts. But generally speaking, I would recommend, let's title the farm into your trust at the moment, and then we'll keep working on the other stuff. Bank accounts and investment accounts, I usually give my clients that information, you know, the information on how to do it, but I don't do it for them. And I want them to do it and explain why they should do it. And I hope they do it. And then personal property, I use a bill of sale, or sometimes we have a document called transfer of assets into trust. So, you know, if you've done trust, you've seen that, hopefully. Anyway, these are the things that you would put in your trust. And then yeah.
I think Daphne, the word funding is often confusing to people, and that because funding, people think you mean just putting money into the trust.
Right.
Where I think, as you're explaining, it's about retitling things that are now not owned by you, but owned by the trust. Is that correct?
Right. So, right there, it's all your stuff. I mean, I call personal property your good junk. So the trust funds can be bank accounts for sure, but they can also be your good junk. They can be your very good stuff. They can be your house. Generally, I don't really have a huge rule of thumb on cars, but anyway. And as far as farm equipment, I mean, later, I would probably recommend an LLC to Glenn and Lee. So I might not be thinking like, or I might be sweeping actually all their farm equipment into the trust at this moment in time, because if something happened to them while they're in their 60s, I want to make sure that we have some sort of probate avoidance of like, this tractor and this other, this baler are now going to go into probate. That's such an annoyance. So part of it is avoiding all those annoying aspects. You had a question, Mike. Yeah. Can you take yourself off mute? Yeah.
Yeah, sorry. We have a couple of questions here in the chat, but I also wanted to just say I've also seen increasingly, if people create an LLC for the farm business, that sometimes their trusts are actually the shareholders rather than them as individuals.
Right. So that can also, if they create an LLC, I want the trust to, the LLC to be assigned into their trust. In that assignment, we also do that probate avoidance as well. So that's another factor with LLCs.
So one of the questions, I think, which is one of the most basic questions here, is should you have either a will or a revocable trust or both?
Oh yes, you should have both. You should never not have a will. Let's put it that way. And then if you have a will and you need a trust, because I think, or you go to an attorney and the attorney says, yeah, like, here's the good reasons why you should have a trust, and I kind of recommend a trust in your case. That's how I sort of operate with my clients. I'll have that conversation with them. I'll give them the sort of benefits and the reasons why. And if they want to trust, they're certainly going to have a will. But the will in that case is going to be called it's not called a pour over will. It's not just a will, but it'll have a paragraph almost like right off. It'll say, anything that I have is going into my trust. So if you end up saying, oh yeah, I bought this parcel that was contiguous to my land, but I bought it separately and I forgot, and I just bought it in my name, Glenn. It's Glenn's property. And now Glenn dies. And now his wife has to go to probate to put that property to her. So then or maybe to put it into her own trust. But at the time she goes to probate, she tells the judge, this property is going to go to Glenn's trust. Now he's dead, so it's an irrevocable trust. So we won't get too in the weeds. It's going to go to Glenn's trust. And then once it's in Glenn's trust, that gets pushed out to Lee pursuant to his trust terms. So, unfortunately, sometimes people die with a trust, but they haven't fully funded their trust and they have to go through probate. Not they don't, but their executor does. And their executor then asks the judge to push it through per the terms of the will. It just says goes to the decedent's trust. It's not, it's not ideal, but things happen like this more than we'd like. As much times as we tell people.
So everybody gets a will, and some people get a trust and a will.
That's right. Yeah, that's right. Is there another question before I move on?
Yeah, it looks like two actually. The first is from Mark, who asked, should life insurance be left to a trust if one is established, or should it go directly to children or spouse? Is life insurance taxable income if used to pay off major debts?
Life insurance is not going to be taxable income. And I think that in terms of where you push your who you name as beneficiary is personal. If you're single or widower, and your kids are not that old, or your kids have shown that they can't manage money that well, and you have a trust, you might name the trust to be the beneficiary of your life insurance. And then you might have some sort of spray like some sort of, as I say, it's like a faucet. The trustee can give then your beneficiaries glasses of water. That's like, here, this is, you don't get like $500,000 in your hot little hands when you're 22 years old and don't know what to do with it. Or 35 years old and have a gambling habit, or, you see your kids, so if you have a spouse, generally most people want their spouses to get the life insurance outright and free of trust. Even most people want their kids to also. But again, your spouse. If you are married and you think my spouse is particularly prone to predation, gullible, or my spouse, so there's that question about being taken advantage of, or my spouse is, I can't think of the other example, but anyway, if there's issues that you think, or my spouse is a spendthrift, she can't, or he can't hold on to $1, then, you might want to push your life insurance into your trust. And again, have the trustee, a separate trustee, doesn't have to be a corporate trustee, but not the spouse themselves, spray out, give the income of each trust plus specific, principal, but it's different than getting, again, $500,000 in hand and blowing it all in 3 days, or being taken advantage of by predators. So I think it's all very specific to the people that I see, but most of the time, I would say that most of the time, life insurance beneficiaries are kept outside of the trust itself. It's not, the trust is not named as the beneficiary, I should say.
So we have two other questions here, and
I'm gonna blow through the rest of this thing so fast.
So by assigning a beneficiary on, for example, a bank account, it will have to go to probate before it can go to the beneficiary? I think the answer is yes.
Right, no, it goes to the beneficiary. So if you can do a pay on death, or if you can hold accounts jointly, certainly with your spouse. But my rule of thumb is, even with your spouse, if you have a trust, do title your bank accounts to the trust. The reason why is because first spouse to die dies, surviving spouse might not have capacity anymore to make changes, so to then retitle. So even if you have like a joint account, and let's say it's Glenn and Lee, Glenn dies first, Lee has the joint account, she now is the account holder, she never does anything with it, she doesn't title it into her trust or anything, then she dies, and then there's probate on that account. So if you have a trust, you're trying to avoid probate, at the very least, that's what you're trying to do. You've already spent the money to create a trust. There's other reasons to have a trust, but in that case, so beneficiary designations are fine. If you only have a will, I would say then that's a great idea. I like that better personally than, like, say you're already a widow, widower, or single, and you have a child, and you name that child as joint owner with rights of survivorship on that bank account, but you have other children, and then you come and tell me, I want to treat all my children the same. You're already not treating your children the same, because that person, that child that you named, now suddenly has control of that bank account. That bank account might have 2 cents in it, or it might have $50,000 in it when you die. It's really hard to know. I've had them all over the place, and I've been get irritated because I'm just trying to, like, tell people, no, you don't want to do that, because you just told me you want to say treat everyone the same. So now sometimes with pay on death accounts, you can name all three. In my example, there's 3 children, but you can name all your children, say, as your beneficiaries. Well, we should move on, because I feel like I'm already running out of time. If I keep the questions going, we'll have time to get to them at the end. Okay, changes to title. Okay. So basically, that slide will tell you what revocable trusts are all about. This is the trust summary. You can come back and refer to that.
So we are gonna send out all of Daphne's slides, including ones that she just wants to run through quickly, so you'll be able to read them later. It's a lot of detail in those stuff.
Yeah. Yes, and like I said, if you had a burning question that I didn't get to, you can email me. Let me just disclaim right now, that email won't be an attorney-client relationship. But anyway, I'll just say that you know, Mike, you told me like we don't need to know about HIPAA. I do like HIPAAs. You should have a HIPAA. You should have a standalone HIPAA from your other documents, because I've run into problems where somebody does have a real reason to want to have health information. If, you know, people go and they see their doctors and they go alone and they have no idea what just happened, and then they come back and their spouse or kid is like, what? Yeah, HIPAAs are good. So review the slide on HIPAA, just to know that it's a standalone document. I give a HIPAA to every client that comes in for estate planning, and I would definitely give one to Lee and Glenn, or two to them, one to each of them. Okay, I think we should just shift over to long-term care, because a lot of people want to know and have like not conflicting knowledge, but like mixed up knowledge of long-term care and Medicaid, long-term care Medicaid in particular, because you hear it from your friend, or you hear it from like reading an article that might be like somebody in Illinois or California, and every state is different. And I'm going to just say right now, I am very familiar with Vermont. I'm quite familiar with New Hampshire. I'm not that familiar with any of the other states in the country. So I'm trying to keep it at a 30,000 foot, but there are a lot of commonalities with Medicaid planning. And I'm going to age Glenn and Lee to be in their 80s now. So they have done their actual basic estate planning, and we've reviewed it every 5 or so years, and we've kept it really relevant. But now they come in and Glenn says, sadly, that he has the early stages of dementia. Not everybody is willing to acknowledge that, but he's open enough, and we've developed a trusting enough relationship over the years. I've been at this a long time if Glenn and Lee are still my clients in their 80s, but it's fantasy. Okay. But this is the reality. He really needs to think about what's going to happen. Now, everyone in every walk of life, I think, has these common goals of staying in their home, maximizing their independence, but they also want to leave a legacy for their kids or somebody else, charities, whatever. They also, if you're coming in as a spouse, you also want the best quality of care. Some people are really willing to say, I want the best quality of care for myself. But a lot of people are like, they're not going to say that, but I'm going to say that on their behalf as their spouse or their child. And everybody says they don't want to be a burden to their children. And I think we should get away from that whole thing. I think that aging, you're just going to be a burden to your children, but it's not going to be a burden. They're going to love it. They're going to want to help you. It's not, that's, I think, the problem there. And people want to avoid Medicaid liens and talk about recovery, what that means. So there's lots of things you could do. You can start by trying to stay in your home. Sometimes you could stay in your home till the end. Sometimes you can't. Sometimes you can downsize. You can buy into a continuing care community. You can go to assisted living, or in the real dire cases, you might have to enter a skilled nursing. There's all kinds of ways that people piece together the payment. Let me just skibble down to the green. Medicare. This is not Medicaid. I think people get confused, but it's also people just say Medicare and mean Medicaid. So I know that. Oh, above that, the reverse mortgage, don't do that. I put it there because it is a thing, but I don't like it. But going back to Medicare and Medicaid, so Medicare is that if you're 65 in this country, and you're at least a citizen, I don't know about a resident, but citizen, you're going to get a Medicare. It's an insurance. It is not needs-based. You can be a billionaire and you can be pretty indigent and you're still going to get Medicare. Medicare, let's say Glenn doesn't have dementia, but ends up having a stroke. And he goes into the hospital for 4 days. And then on the 4th day, they put him in a rehab care residence. And they say, okay, you know, we're going to try to work with him to get him back. And most people at that point are like, yeah, I'm going to be in rehab for a little while and then I'm going to go home. And some people can. So Medicare will cover that 4-day stay in the hospital. And because he's stayed more than 3 days, this is like a really important rule. You have to be at 3 days in the hospital. And once you're past that and you go into rehab, the rule is the first 20 days of the rehab, Medicare will cover that. The next 80 days, they will be in an 80%, you cover 20, they cover 80. And past the 100-day mark, they're like, okay, no more Medicare. Medicare covers, like, I am going in for cancer treatment. I am going in for dialysis. Medicare, and this is after you're 65, Medicare will, you know, those are the kind of things you don't need to apply for Medicaid for. But if you need long-term care, because let's say after the 100 days are up, Glenn realizes that he is not able, Lee can't take care of him at home and he needs more skilled care. And he goes to live in a residence for at least, you know, a significant period of time. Then Lee and Glenn have to maybe reconcile to a needs-based program, which would be Medicaid. Now, whether they're in the cohort of people that can apply and be eligible, we'll get to that. But that's a very different, that's a needs-based program. So kind of like TANF, like a welfare program. It's not for everyone. So if you can avoid Medicaid, it's always great. But the reality is we're living really long lives. We have incidences that require us to go into long-term care residences, or sometimes you could do this at home depending on your state and rules, but and the cost, but yeah, Medicaid is not necessarily for everyone. But I do want to talk about the eligibility. Medicaid has 3 parts. There's a medical part and an income part and an asset part. The medical part is basically your activities of daily living. So what does that include? Can you get out of bed in the morning? Can you make it to the bathroom? Can you take a shower? Are you taking care of yourself? Can you go to the bathroom by yourself? Can you dress yourself? Most people, by the time they're applying for Medicaid, understand that they're applying for, and generally you don't apply for your own Medicaid because you're kind of not in the frame of mind to do so. But your person in your orbit who's applying for you understands that you need this kind of help. You have a lot of medical history already. But usually the department of or the agency that's in charge of Medicaid in your state will still do an assessment independently. People don't think a lot about income. They think a lot about assets when they think about Medicaid eligibility. But your income is important. You can actually be over income if, let's say the Medicaid department will pay $5,000 for a bed that would be $8,000 privately. And if you add up all your stuff, your pension, your this, your that, on Glenn's side, he doesn't have a pension, but if it's Lee's side, she does have a pension. If she's the one that needs to apply for Medicaid for whatever reason, she might be over the income. If she's over $5,000, she would not be able to get Medicaid in that circumstance. In Glenn's side, at this point, he's in his 80s. He's getting his Social Security. He might have a small required minimum distribution from his IRA. And he has small investment income, but he no longer is working. So if we say, oh, they didn't do any sort of like rental of their farm, let's say none of that is going on, his income might be very low. So likely he's going to be eligible income-wise. We'll get to the assets in a minute. The wife's income, if the wife in this case, or the spouse that's not applying, the department doesn't care about that person's income. So sometimes you get people even in their 70s, even in their 80s, well, our president and presidential candidates in their 80s working, right? So they're still making income. They're still having earning. They're still earners, and their income is discounted. Can be a good thing. If on the other side of income, if there is a whole formula that the department uses when they figure out spousal share. This gets in the weeds. I don't think we should talk about that here, but I think that it's important to keep in mind that there's an income assessment. And then, of course,
can you give an idea of what's the income threshold, at least here in Vermont?
Well, there's not really an income threshold. I think what happens is each place, like let's say your place, like I gave the example of the bed privately is $8,000, and Medicaid says to the nursing place, we'll give you $5,000 on our Medicaid side, and you have less than $5,000 in income as the applicant, you're eligible on the income side of things. That's how I look at income eligibility. It's not like you're capped out at, because if Medicaid's if the department is willing to give more to that particular nursing home or assisted living, it's all going to be variable. It's not like there's a one number. But generally, if I get somebody who has like when I do get like principals or certain people who might come to me and talk about Medicaid, and I see somebody has like 7,000 or 8,000 in earnings after they retire because they have big passive sources of income. Generally, I'm going to say you're probably able to manage your care without even applying for Medicaid ever. Because the other side of that is, with $5,000 or $6,000 or $7,000 of income every month, could you possibly even stay at home or be in a place of care and pay for it yourself? And private pay is good, but private pay now, by the way, can be up to like $13,000 a month. So even if you have $7,000, it might not be enough. And the downside is if you're in that spot of not being, if you're having too much income so that you have more income than Medicaid allows, but you cannot afford private pay, what do you do? And in those cases, one, you might have to shop around to different places to find a place that you can afford. And two, you might be able to negotiate with the place you're in, depending on their circumstance. So if they're, not negotiating with every single person, they might be willing to do something. That's a pretty big dilemma, but the reality I've seen is most of my people who are applying for Medicaid their income is Social Security, which isn't, I mean, max would be like 2,000, 2,200 a month, and some other passive, you know, maybe an RMD or a small passive income from the investments. And so they're never really exceeding, say, $3,000 on their side. So I don't worry often about applicants exceeding the Medicaid rate for income.
So I think though it is, since it is a program that is for very low income people, there is going to be a threshold. And I think to the point you've made earlier, Medicaid is different from Medicare and a lot of other federal programs in that it's a state and federal joint program. So that's why, you know, Daphne's making comments about it depends on which state that you're in, because even though you think of Medicaid as a federal program, it's a joint program in reality. And so each state gets to make up some of the rules, and it's including on income and asset aspects. And that's why talking to the attorney in your own state is going to be very critical.
Yeah. And like when most of the people who are applying are past the age when they're earning regular, you know, they're not out there working anymore. So they're not earning in the way they did once. Most of their earnings are passive. And really the indigent part of it, the rubber hits the road at the asset resources area more than anything in most people's cases. So go ahead.
So just one more thing, just on the income side, in the farm situation, the common one would be the farm rent, as you mentioned earlier, or if you're doing an installment sale to sell the farm assets or shares in the LLC to the next generation. And so you might be collecting that income, and that's all going to be considered in the determination of your income eligibility.
100%. And one of the things that we could just jump to in that scenario is if Glenn and Lee have done that installment sale and they're both buyer, you know, they're both getting the income. One thing to look at is whether, you know, the operating agreement and bylaws or anything that you have allows Glenn to sell his shares to Lee. And then suddenly she's the main income earner, but she's not the one that's applying for Medicaid. And Glenn's income is suddenly negligible because he no longer is a recipient of the farm income. Whether that can work, you know, this is not the forum where I can like deeply think through how does that work, but I think that's sort of what you're trying to do. You're trying to like get the person who's applying within the framework of what is allowed, obviously, Medicaid eligible, because most people are not millionaires trying to become Medicaid eligible. Most people who want to seek Medicaid know that they're doing it because they don't want the spouse that's outside of the institution, for better words, outside of the medical residence, to become indigent herself in this case, because she's providing every last penny to a nursing home or something. So anyway, I just want to like, I say assets and I say resources because the departments tend to use resources instead of assets. It's a very bothersome. But they're really, to me, they mean the same thing. And there's two classes. There's the countable and there's the non-countable. And the non-countable is important. It's your primary residence, and that includes the land. And at least in Vermont and New Hampshire, I think it counts like all the land you have. So if you have your house on 200 acres, okay.
It's got to be contiguous.
Contiguous, yes.
So if you have subdivided lots, fields, and this is a common problem for farms, fields and woodlots that are not contiguous to where your actual residence is, those are countable.
Right. And so when you're younger and you're amassing your land, because you're buying it from all the landowners around you, you might want to make sure that your deeds connect all of that. But if you had a better reason to have it subdivided and to clearly delineate all these things for whatever, for insurance or for liability purposes, it's one of those things where you might not always get it all, right? So, and if your land is not contiguous and they count, they say, okay, well, now you have this parcel here and that parcel there, excuse me. Unlike income, assets are husband and wives come together. So you got to be careful, because each of these properties could be whatever value there, 50,000, 100,000, 200,000. And those are going to bar the door from being Medicaid eligible. And most people don't want to, the last, place the farmer wants to raise funds for their care is from selling their property outright, and being forced into that. And it's one thing to, be younger and say, okay, this is the plan. But it's another thing to be like, I now am forced into making this very difficult decision. So hence we're here. The countable, so primary residence vehicle, at least one, usually one, and all of your personal property. And then countable are bank accounts, investment assets. In most states, it's that comma shouldn't be there. In most states, IRAs are going to be part of the countable assets. And in Vermont, they have a very unique treatment. So the best. It is really unique. I think only Vermont and maybe one other state treats IRAs this differently than most states. And most of your whole or universal life insurance, the first $1,500 is in the non-countable category, which is like, as we like to say, bupkis, not going to get you far. Okay, and then depending on the state you apply, the applicant, the one who's applying, can retain about $2,000 to $3,000 in countable resources. The non-applicant spouse can retain about $150,000, depending on the state. Not a lot.
So Daphne, on the primary residence, there is a cap in some states on the value of it. I think it's
713 in Vermont. It's $713,000 of equity. So if you have leveraged your property, but you have less than 713,000 of equity, that's okay. But if your farm property is your house and your acreage is $1 million, you are, now like some $287,000 in the hole, and you're not going to be able to get Medicaid because they're going to say you're over-resourced. It's a complicated conundrum because it's land, and so you can't necessarily, without selling it, you can't raise funds. Obviously, if you sold it for $1 million, you wouldn't be Medicaid eligible either. So yeah. I put that in a slide later on when I talk about property, real property. I do think that spend down and gifting can be important to know about before you launch into a Medicaid application. If you gift for less than fair market value, that creates a gift situation for the state. Sometimes, like in real property, if you're selling your property and it comes in far less than fair market value, the state will come after you and say, at least tell us why. We want a letter from the realtor as to why a $500,000 property sold for $250,000. And of course, there's many reasons why. Like sometimes properties just fall into disrepair and they're definitely not going to be valued at what was thought to be their fair market value. So you sometimes have to just lay out the scenario for the department. The gifting has a whole penalty period. Whatever you gift has a divisor. The divisor is not $10,000. This is just makes it easy math. But if you gave $100,000 gift, whether you gave $100,000 in farm equipment or $100,000 to your grandchild's college fund or whatever, and now you suddenly need Medicaid, and it's within a 60-month period from the date that you gave that gift. If the divisor is 10,000, you're going to have a 10-month penalty period. So now you've said to the state, I'm indigent. I have less than $2,000, but now for 10 months, they're going to make you pay privately. And you think, well, how am I ever going to do it? It's like a big catch-22. So one thing that I often will try to tell the state is, this person did not make that gift because they thought they were going to need to get Medicaid. They're not trying to give away their money. Also, small gifts, birthday gifts, most states aren't going to really look at them. Think about, like, if you start giving $1,000 gifts in a regular way, that I think is what's going to spark their interest. And sometimes gifting makes sense. Sometimes people have the ability to do gifting, and when I say gifting, they could discount their property as well. That, like I said, if it's not for fair market value, but it's still discounted, and they still have enough resources to say last them for this 5 years. It's a bit of a hedge. So Glenn might say, well, now I want to do some sort of discounted discounted sale to my son because he's the farmer. And I want to, and I have my IRA and I have my investment assets, and I think they're enough to float me along for 5 years. And I don't think I'm going to need to go into any kind of assisted living or nursing. And Lee says, yeah, and I'm gonna, let's just split the difference. Let's say they come in their 70s. So before he finds out that he really has anything, which is critical, and Glenn says, this is like one way I think I can make this happen. And then after the 5-year period runs out, that gift is done. No one's gonna look at it. And farm now belongs to the son, and everybody kind of goes on their way. So that's one way to think about sometimes how gifts can work if you're trying to push away property from yourself for Medicaid purposes down the road. That's not what most people can do, I have to say. And most of the time I come up with like a plan to buy something for fair market value, improve the primary property, make sure that uninsured medical care is taken care of, paying off debts. Most states, I think, have these burial accounts that people can set up for about $10,000 per person. And there's also Medicaid compliant annuities, and this is not there. Those are too weedy to talk about today. An irrevocable trust can also work for a spend down tool, but you're basically gifting your property into the irrevocable trust. So you do have the 5-year look back period. You can take income from like income interest from the trusts, usually in most states, but I don't know about all states. But if you do put your property into an irrevocable trust and you don't make any other gifts, then after that 5 years, that property is outside of the look back period. But so anyway, it could be a good strategy for healthier people who have other additional funds. It's not the norm. I don't do that many of them. I think other attorneys do more of them than I do, but most people also don't want to have no control over their property, so that becomes an issue. So anyway, and here's where I talk about the primary resident Oh, I did keep enhanced life estates up there, but what I meant to talk about is just, you could delete that enhanced life estate. In Vermont, we do have this tool. If anybody's in Vermont and wants to know about it, that it's like an awesome statutory, tool to help prevent your property from probate. It helps prevent from Medicaid recovery. It's amazing.
So I think you could just say a few more words just about how it works, since
Okay.
we do have a number of people
Okay.
here from Vermont. So
Okay.
just a few more, and then we should get to some questions and then the business.
Yeah, then we should take a small break with questions. Yeah. Yeah. And so what happens in Vermont is you can take your current deed and you retain and what is called an enhanced life estate. It lets you obviously retain the property and live there for as long as you want to live there. But it also allows you to sell the property, mortgage the property, gift the property, usually don't recommend, or do whatever. You can transfer for consideration or no consideration, for money or no money. And you name in that life estate deed your remainder beneficiaries. So if I have 3 children, I might name all 3 of them. If it's the scenario with Glenn and Lee and they have only one child who's interested in the farm, I might only name that one child, but I might actually, in going back to the estate planning, have talked about using my life insurance or other, or my IRAs or any other of my accounts to my other kids so that I balance things out a little bit. Now, I don't think in their case, given what I said about what they have, unless they've really, really taken out, pretty decent life insurance policies, maybe their daughters who live in other states and are not interested in the farm don't equalize to what their son is. But generally speaking, that way, at least the daughters feel like mom and dad didn't, just love, whatever, brother. Can't think of a name, brother, more than they loved us. They like tried to do what was right. So anyway, that's Vermont. It avoids this enhanced life estate, allows for a lot of flexibility with the life estate owners. You don't own the property the same way you owned it before, but your children, it doesn't vest in your children until your death. So when people say, well, I don't want my children to be second homeowners, they're not going to be second homeowners. It also means that like Glenn and Lee are both enhanced life estate owners. So one dies, the other remains an enhanced life estate owner. And it shouldn't be confused with, there are still simple life estates you can give to somebody if you're in a second marriage, or if you're in a partnership with somebody, a life partner, and you're not married, and you want to leave that person a simple life estate so they can remain in the property after your death, there's still a way to do that. But yeah, it's an amazing tool, and I wish like all states would adopt it, because I don't think the states that are saying we're really recovering from real property for Medicaid purposes are really raking it in. I don't know. I think it's just like kind of a real conundrum, but.
Well, I think as we wrap up this section, I think that's an important point. Is this is not just about the eligibility for you to go into the nursing home and what they're going to pay while you're there. In some states, they're very aggressive about, after the person has died, of trying to recover some of what Medicaid paid for that nursing care. And I've been warned by attorneys in Maine, for instance, that they're very aggressive there about recovery. And so you think you've kind of dodged the bullet, and now they're looking for the money because it's, so you have this farm, it's of high value, the person's dead now, we need to recover some of what the state has paid through this program. And that's where you really need to talk to a good attorney like Daphne in your respective state towards being able to plan for that.
Yeah, it's really terrible. In some states, it's just in Vermont, the whole statute, it was incredible that they codified this, but the whole statute is this avoids probate. I kind of made the mental leap because I do this all the time, but the avoids probate, and the only way Vermont Medicaid department can recover is through probate. So if you avoid probate entirely, which most indigent people will do because they have nothing, that's why they're indigent and that's why they can get Medicaid. But if you have a house and you forgot, you can still get Medicaid when you have a house, right? Because it's not countable. So if you forgot to do something with that and then you die, for sure, if it goes through probate, Vermont's also going to try to recover. In other states, they don't have this. So if you can't do a enhanced life estate. So if you and like moreover, although you avoid probate by putting your property in trust, many states will make you take it out of your primary residence out of your trust in order to apply and be eligible for Medicaid. So you're in a catch-22 with other states, and I'm sure they figured out some ways to like manage that a little bit. But maybe that's why people do irrevocable trusts in other states. I don't know.
So do we have any questions on the estate planning before we finish up in the last 40 minutes or so on business entities and using those for transfer? There was a question, but I think you've already kind of answered. Is the primary residence still non-countable if you're living in an assisted living? And I think that's the whole point, right? Once you're going to assisted living, you're trying to figure out how to pay for it. So it's still uncountable to make
it's not countable. One of the problems with, well, let me just address it this way. In Vermont, one of the problems that I do run into with enhanced life estates is like, oh, it's such a great tool. But if you're a single person in any state and you're trying to apply for Medicaid, it becomes harder. All the tools to preserve your assets are harder when you're just alone. Because you think about it, one of the reasons that the federal government came up with their 2006 Act regarding Medicaid is so that the surviving or the spouse that lives outside of the institution doesn't become impoverished. But once that spouse is gone, there's no concern about preserving money for the next generation. So there's that. Once you're in, so let's say you have this house, and whether you have it in enhanced life estate or not, you go into residential living, you're a single person, nobody's living in your house suddenly. And you have carrying costs. You might still have a mortgage, but even if you don't, you have property taxes, you have insurance, and you have maintenance. And leaving a house without a person inside can be a problem too. So there's a lot of things that usually I talk to. At that point, it's children who, because parent is the person in the assisted living. And there's choices to be made. Sometimes the family decides, you know what, we have to sell this house. It's like totally not worth it to keep it. But sometimes the children themselves, either one person or a combination of family members decide, hey, we're going to pay the carrying costs of the house. And this might be very true with like a farm property where you think, I want to inherit this farm, or not inherit, but like, you know, I've already done all this stuff, or we've done some work to pass this farm to the next generation. So maybe the next generation starts paying the carrying costs for the person in the assisted living. And if you say on your, at least I know for Vermont and New Hampshire, if you say you have a intent to return to that property, they don't, there's not a check on that. I think you should always just say you have an intent to return to your property, because you always do. Like, I have an intent to just live in this nursing home forever. I mean, clearly we all can just really say, yes, we have an intent to return to our home. So I would say that you can easily say this property is non-countable forever and a day, but whether you really want to hang on to it is another story altogether.
So I think with 40 minutes left, we should go on to the business entities.
Yes, indeed. Okay. There's lots of ways that you can create a business, structure it. But today I'm just going to focus on LLCs. I'm going to skip through slides that I didn't take out, but I think they're good for you to have, because the LLC, sometimes the way I talk about it will juxtapose with like, oh, instead of, a sole proprietorship, blah, blah, blah. So now you'll know, but I'll just race through. These are just for your packet. Okay. So LLCs are in most states, I think, good tools. They're pretty flexible. The contributions to an LLC can come in any form. You can have as many members. They're not called shareholders like corporations, although sometimes I do speak in terms of shares and interest, and I use a lot of those words interchangeably, but most of my clients are LLCs if they're going to be a corporation or incorporate or business entity, I should say. And those members of the LLC can be individuals, or they can actually be corporations. There could be whole investment corporations that are part of members of the LLC. Members have personal liability protection, which is why people really like this. And the framework can allow the business to grow and change and pass on to the next generation. There aren't that many disadvantages. I would say that having legal assistance is probably a good idea when you're thinking about it. It's a little, a cost, and I would put it as a cost of doing the business. One thing I don't want to forget about, though, Mike, and put on my extra stuff, is LLCs need to think about this brand new Corporate Transparency Act. Are you talking about that? I didn't look at your slides of your presentations.
No, and I don't know that we want to spend too much time on.
No, we don't.
Okay, we could probably just let them talk with their own attorneys about that. So
I think that everybody here who's an LLC or any other kind of company or any kind of business structure should look at the FINCEN website. It's the federal government website. Look at what they're talking about and look at what you have to do. And if you've just created or think you're creating your LLC in 2024, then you have a short window, 90 days from when you incorporate or file your articles of organization with your Secretary of State's office and get your articles, to filing your CTA, your application. It's easy. It's not hard. I don't think it's super hard for like smaller LLCs. But I don't want to not say this, because 90 days is a very short window when you're thinking about 2,000 other things. And lawyers, we're kind of like this right now. Many of us are like, we don't know. We're going to just do what we do. We're not really getting super involved yet. At any rate, need to mentioned it. Good. Write it down, everybody, because it's not in these slides. Okay, so you choose your name. Most farms have a nice name. You file with the Secretary of State's office, and you get your EIN number, and then what you really need to do, really, unless you're just one person, if you're just one person, you probably don't need an operating agreement right away. But if you're more than one person, if you're more than one person, I highly advise an operating agreement to talk about all the that's what's really going to structure your LLC. Okay, LLCs are good for farm families or farmers, even when I think about senior generation, junior generation. They're flexible in their ownership structure. There's different classes of membership you can arrange. the operating agreement can be very specific and help you with disputes, help you with, and this is particularly true when there's an exit strategy. So, you know, buy, sell, and how shares will be transferred. You can plan for death and divorce and other situations that members would have that would shake up an entity. Could all be prescribed. And then you could even add in like how the next generation will come into this, if they will come into it. So all kinds of things. And then you could transfer your farm in a slow and steady way through an LLC. The younger generation can purchase interests over time. That can be part of the operating agreement. All these things, voting rights, mediation, all the important things that you think about, like, well, there's few people, maybe a few different generations, a few different roles. Voting doesn't have to be, if somebody has 80% of the shares, they don't necessarily need to have 80% of the vote. They might, but they might not. So you can do whatever you want to do. You know, basically it's like you have a blank slate. Then the senior, in this case, like Glenn and Lee, can create the LLC and move the trust into, or move the farm into the LLC, and then retitle the LLC into their trust. Then the seniors and their next generation can create the operating agreement. In my case, it is Glenn's and Lee's child who would be the next generation, and he has a wife who's not working on the farm. And so there needs to be some thought, perhaps, like, well, we don't necessarily want son to get divorced and then suddenly, or to die, and then suddenly wife, you know, the will guides, and suddenly wife is inheriting his shares. So there's lots of ways to make sure that if something happened to the next generation, that it's not just or even the senior generation in this case, who are more likely to die before the junior generation, that it's not just an automatic passing this way or that way. Because let's say it's Glenn and Lee also, they die, they don't necessarily want their shares to go to all three children equally. So they're creating something very specific in this operating agreement to guide to the son, and then they want the son's share not to be guided even to his own children, depending on what this family is thinking about, right? And if it's not the son, if it's a lot of people are having, all their children are not interested in their farm, so they're going to they're finding outside people who want to buy in and take over. And so the junior generation could be someone completely not related to the family. And in that case, they also want to make sure that, you know, whoever is it's not just like anybody is inheriting from the junior generation. And you also want to make sure that, just like, you know, if you own a piece of property and you own it all with your siblings, say, and then as people die, a kid, you know, their children inherit, and suddenly you have all these cousins owning the property together. You want to avoid that scenario completely. And so the LLC structure, operating agreement structure, allows you to do that. Okay. I would definitely say use an attorney, and always have the LLC, the purpose of the LLC top of mind when creating it. Let's see. Oh, there's a lot of things on this slide. So these are various questions I have for you to ask your lawyer, or put out to your lawyer, or ask yourself first, really. Like when you think, oh, I'm gonna transfer shares, is it somebody gonna give me X for each share? And we can talk about valuation too, but before we even get to valuation, are you looking for money? Are you looking for this person to buy through sweat equity? And what is that value? So there's a lot of questions to ask. Voting interests, like I said, is every person going to be equal, have equal voting, or in this case, Glenn and Lee going to have priority voting, a majority voting over junior members? Or when does that change? At some point, Glenn and Lee maybe start getting way out of it because they're not working anymore. They're not really calling the shots. They're not going to make the business decisions for the farm. Also, what general decisions even have a vote? Are there going to be certain things that members can do without taking a vote? You have to know the corporate formalities. That's not a question, but you might want to ask about those. Then voluntary and involuntary transfer of interest. So there's going to be a mechanism like, I cannot do this anymore. I want to get out of it. How does that happen? That's like, a voluntary. Involuntary is, oh, we have a structure where everybody needs to contribute $25,000 a year, and Joseph hasn't contributed his share this year. And what is the mechanism to either try to get Joseph to do that, or if there's a complete failure, how do you expel them from the LLC, basically? And withdrawal is kind of part of that, like the dissociation, or expelling someone is also a dissociation. So a death is also a dissociation. So there's all sorts of ways to think. And then figuring out divorce, a divorced member status. Certainly, like, you don't want the LLC as an asset to a divorcing person to become part of how their marital and then divorce situation is happening. You don't want to have some third party who's like totally outside of the farm situation stay a part of the voting membership or anything like that. And then disputes, disagreements, usually there's like mediation is pretty much more common than I would say like binding arbitration, but there's all sorts of things you can put in your LLC agreement about disputes. And then complete dissolution, what happens if this doesn't work out, and you count for that. Any questions before I keep going, or good? All right. Yeah.
I'm not seeing anything.
Okay.
In the chat.
All right. So these are just provisions. If I have like an outline of what's in my LLC operating agreement, these are generally the types of things you'll have in them. I did want to address some of these things. Capital contributions are what everybody puts in member-wise, usually at the beginning or ongoing. There might be capital contributions ongoing. Then in terms of accounting, there needs to be record keeping. The old place was like a record book, but now it's probably, an online software, and that's nice. You can use this balance sheet to capture every member and every member's percentage of contribution, and then their profit and loss as to what they're entitled to. So that's what I would say about capital accounts. I just wanted, I think I threw in assigning interest to trust, so I didn't forget about that, but I talked about that already.
Could I just make a few
yes.
comments on the previous slide there?
Sure.
So maybe just flip back. So the capital contributions, one of the things that this is where this tool can sometimes really help clean up some of these transfers, because what I've seen many times working with many dairy farmers over the years is they've gifted calves or heifers to their child, and then supposedly they own that part of the herd, and or a tractor or something, and it's never documented anymore. And so when you start up an LLC, then this was the capital contribution. This is the portion of the business that younger generation already owned, maybe earned through sweat equity at the beginning. And then the tracking with the capital accounts is where I see a lot of these things fall apart because people are not doing what's actually says in the agreement as far as tracking everyone's contributions and everyone's values and the value for the business. Usually it's as simple as keeping track of your balance sheet every year, keeping track of your equipment inventory, your livestock inventory every year, and every year about this time of year agreeing this is the value of the business and this is the share amount that we each are owners in, our ownership shares of it. And then what does that translate into cash values in terms of the capital accounts? And you can work with your accountant on it. And unfortunately, what I see is when there's a death or somebody is leaving the business because they want to be bought out for whatever reason, there's a dispute or something, they haven't been keeping up on that value of the business, and they haven't been keeping up their capital accounts. So the starting point is a disagreement about what is the value of everybody's equity. And that's not where you want to be. You want to keep track of it, not waiting until someone dies or somebody wants to leave or there's some other disagreement.
That's very good points. And I do think working with an accountant is great. I also think that, like with any group of people, there are going to be strengths bubbling up from different people in the organization. So hopefully somebody has pretty good bookkeeping sensibilities about them, kind of attention to detail, and will be the keeper of some of this. And these days where people are using the computer, it seems like it would be an easier thing to input, but I do think there are very fine details with the farm because of, like you said, if it's a part of a herd, or if it's a part of a stand of trees. And then on top of that, there's the sweat equity and what is the value. And that just reminds me that you also asked me about valuation of shares. And of course, valuating, that's like, I can't talk about it in terms of like, what is a particular calf valued at, but you are probably going to have to get down into the weeds if that is how you are looking at your capital contributions and your capital accounts, and what the value of that sweat equity is also going to be important. You're going to have to put a number on it. When I think about valuation in a bigger share situation, I think, well, you want that to secure bank financing, to determine what kind of insurance, like how much insurance you carry. If you're selling, you also need to know, like, if I have 50% of that, I want to know what is the value? What is my 50% worth? Certainly with buy-sell agreements, you would want an appraisal so that you would have a sense of what it is that the redemption amount is. And again, that's also goes into the whole, if you're doing a buy-sell agreement, you need to know the value so that you maybe need to get the life insurance to provide for the buy-sell. And how do you do that? So I think valuation of the farm is a really tricky, and I won't say more than like give you this kind of really global.
Well, that's where I'm saying that where I see.
Yeah.
So first of all, one thing we haven't been specific about is it's very common these days that you're creating a business entity to this LLC to transfer intermediate and current assets and not necessarily the real estate right away. And so there's the valuation of that, which if you keep up on your inventory of that each calf and piece of equipment every year and all the depreciation on those, what they're really worth on their fair market value towards your balance sheet, which you may have to do for your lender anyway, or your insurance company anyway. If you document that you're every winter that you guys are agreeing that this is the value, then if you do get to that buyout, that's where it's important. Then the real estate is could be separate and held differently. It could be held by individuals or it could be held by a separate LLC, and that's becoming more common. And that's where you would definitely want to bring in an appraiser, maybe at the point of transaction rather than on a regular basis because appraisals are expensive. But to know what the value of the equity is in that piece of real estate, you're not going to come up with that yourself. You're going to have to use an appraiser. As Daphne was saying.
Yeah, it's really expensive, but we have to. The other thing again, this is probably more specific to Massachusetts. If your state tax exemption is still $1 million, you probably want to know the value if you're doing gifting to the junior generation, because if you gift, whatever you gift is probably reduced from your estate tax exempt amount. So something to keep in mind, a little esoteric, but I didn't want to lose that thread. You can read about the taxation of your LLC, but you can either, whatever you choose at the federal level will be what you do at the state level. You can flow it through you, or you could be taxed like a corporation. Most people flow it through themselves. Go ahead.
So I was going to say, so next week we will have an accountant here, and we'll be talking again about taxation in the LLC. But you do elect it as a pass through, so there is no LLC tax. There is a tax. You're either taxed as a partnership or as an S corporation. Very rarely would you be taxed as a C corporation.
Right. So, I also just things to read about annual reporting. Just know that there is annual reporting generally for this. There's like a re-upping with your Secretary of State. So you should just kind of peruse that when you have a chance. I don't think an LLC replaces a trust. An irrevocable trust sometimes has similar guidelines to operating agreements. I think in the best circumstance, you have your LLC and you also have your revocable trust and you also have your will. Yeah, that's what I would recommend. You should think about life insurance as a succession tool. I'm running out of time, so I'd rather take questions rather than like going through some of this.
So let me go ahead and put questions in the chat or feel free to open your microphone. But what I do want to say on the life insurance, that's a common tool that I'll see used where, and sometimes lenders will require this, that they'll want life insurance on each member, particularly in the business entity. Again, the entity that's holding all of the actual operating parts of the business, they'll want to see them having life insurance equal in value equal to their equity in the business, so that if they die, the life insurance will be able to pay out their estate. Because commonly, if you've got a spouse who's not in the business, you've got children that are not in the business, whether they're minors or adults, and then you die, the other members of the LLC don't necessarily want your kids or your spouse to become members. And so what I typically see is they become disassociate members, which means they have no voting rights. They only have a right to the equity and any distributions. And so they generally want to take advantage of your buy-sell agreement. And so with the buy-sell agreement, they'll have that valuation determination we were just talking about, and then they will if the life insurance is there to buy it, then the farm doesn't have to go into additional debt to buy out that widowed or widower spouse or those children, and you don't have to take them on as members, but they're still taken care of. And I'll just say also too, on the buy-sell agreement, something we haven't specifically said is the buy-sell agreements really need to think about what the farm could afford. If somebody says, I'm done, either because they're retired or they're disgruntled or or they get disabled in a farm accident or some other reason, that the farm can actually afford it. So we'll put in those buy and sell agreements things like it has to be bought out on a 10-year term. Again, this is for non-real estate at the FSA interest rate, something very specific, so that if you look at it periodically, you'll be able to know that that the business will actually be able to afford to buy out a member, including if somebody's ready to retire and the younger generation, are we going to be ready to buy out mom and dad or the previous owner if you're not related?
Right. Because it's not always death that creates that scenario.
Right.
Yeah. Yeah. All right. And I just want to, there's a few more slides. I don't even know, but this one talks about installment contracts and leases and traditional sales. So there's, a few more slides, and they really guide, well, what are the more details of, now Glenn and Lee want to kind of start moving away from being the primary senior farmers, and they're trying to do something with the junior generation to push their farm away from themselves for a variety of reasons. Maybe this is the way they raise their income, so they can stay off of Medicaid and pay for their own long-term care out of pocket, or perhaps even stay on the property, on the premises, maybe not in the main house. Maybe the main house starts going to the junior generation, they put a different house on the property and they live in that house. Or maybe this is happening and then gets swapped, so these are all kinds of things that you could think about when you're doing that. But I don't want to hold up questions to talk about this, and this might actually come up as well. So
yeah, so I'm looking for questions out there. Remember this, you have an attorney here that you can ask questions for free. So here's a good chance to ask questions. Well, we have a couple on the state ones we could come back to.
Yeah, but let me actually, I wrote down some of the thoughts you had, Mike. One is a frequent question is the member managed versus manager managed when you're creating your LLC. Frequently, more often than not, we recommend members to manage, and it's just what it says. Members manage, meaning they're in charge of day-to-day decisions, and manager managed means that you as members have said one or two or more people are appointed to make the decisions. So I would say if you have a pretty big unwieldy LLC with lots and lots of members, you might want to be manager managed. Generally speaking, in the kind of small farm community that I'm in Vermont or New Hampshire, it's like a few people, might be more than two, but it's not usually like 26. And so, member managed seems to be the way to go.
And the only time that I've seen generally people go with the manager managed is if they want to have all of their children, so it's usually family oriented, children be owners in the real estate, and they're putting the real estate into a separate LLC. So this is usually, again, different LLC than what the business is in. So the business might be just the members who are actually operating the farm. And then the real estate, all the siblings might be members, but the ones who are actually operating the farm become the managers, and they're the ones who make the day-to-day control, so that the non-farming members can't make decisions except maybe about the sale of the farm. There might be a few designated areas where all the members have to vote. on what's going to happen. And it's not always, that's still not always the best strategy to include those non-farming family members, but in some cases that's what people want to do. The question always becomes, what's the buyout later if one of those non-farming members want to be bought out? In some cases, they're not eligible for a buyout at all unless the whole farm is being sold, right? So that'd be one of the reasons that the family does that, is so that they can, know that, well, we're giving this to the farming members, we're excluding the other members otherwise, but if those farming members do sell the property, then that's been gifted to them, it's going to be a vote of everybody that's inheriting it, and then they're going to all benefit from it.
Right. Any other questions, or should we?
So yes, do LLC shares become divided automatically if the owner with multiple children dies, and can multiple children co-own one share?
One share? Well, I don't. So, right, if the LLC is written the way you want it to be written. So if you have multiple children and they're all members of this LLC, and you are the senior generation and you die, you could, depending on what you want to see happen, you could transfer whatever shares you had to the next generation. Just transfer, as in, whatever, 3 kids, 30%, 33%, whatever, or 2 kids, 50%. I don't think, generally, I wouldn't, that just seems almost like having a will or a trust. I guess when I think about an LLC and the transfer at the time the senior generation's death, I would want to be a little more prescribed about exactly how you're transferring the property, because not everybody's interested in having the property. Some people are just interested in having the funds from the property. So if you just give it to your kids like that, the next generation like that, 2 of them might be like pushing for a sale, and the other one really wants to work on the farm and can't afford to just buy it outright, like from their siblings. So you want to really be very specific about how this will all happen. Maybe you get the other 2 out actually, but it's like you were talking about, Mike, an installment over a term of years, because there's not usually ready cash to buy out the other ones. And you don't necessarily want to just keep the other ones in against their will in some ways. So,
yeah. And I think the simple answer is nothing's automatic here, which was what the question is. And so it's going to be, and I tell people, you want to make sure that the operating agreement doesn't conflict with your estate plans, which is why we're putting all these things together, right? And so, as I was saying, a lot of times if the children are not members of the LLC to begin with, the typical operating agreement will say, well, they can inherit the interest as disassociated members, and all they're going to be eligible for is the equity per the buy sell agreement. They're not going to have any control over it. If they're members, they certainly could be inheriting the shares too, and still be, because they're already members, right? So there's ideas to not force people to become partners in these agreements. And so, but how you leave your shares, whether these people become members or disassociate members, or just increase their membership share, is going to depend on your estate plan, your will, or your trust. So these have to kind of work together. You work with the attorney to pull it together.
Yeah.
And I'm not sure if I just answered the last question we have here. And I'm going to just say 2 things before we close up in this last question. Will has put the evaluation form in, so please fill out the evaluation. Number 2, finding an attorney can be a challenge. We do, when we work with people, try to provide attorney referrals. There's also the Legal Food Hub in each of the 6 New England states where you can get attorney referrals. Talking to other farmers about their experiences working with other attorneys is useful. So, and it looks like I did answer, yes, it looks like the last question was answered in how I was addressing the earlier question.
Yeah.
So perhaps if there's any last words, Daphne, in the last 2 minutes you want to pull together, and then otherwise everyone, please fill out the evaluation. Thanks for being here. Please come next week where I'll be talking about retirement at the beginning, and then Nick Bullock from Farm Credit East will be talking about taxes. And Daphne, you have any final words?
I just want to say that this is a pretty complex area of several areas of the law. And I did like that you said the relevancy of your estate plan with your LLC. It all has to sort of jive, right? So I talked about all these things sort of separately, but really they all dance together in this fine minuet. And it's complicated. And so, but don't let the perfect be the enemy of the good. Try to, work through some of the complexities with people like Mike and with a lawyer, and try to get something hammered out, because I think that the peace of mind that you have of pulling it all together is really valuable as you go forward.
Thank you.